Companies Act, Section 221, Freezing of Assets of Company on Inquiry and Investigation. Section 221 of the Companies Act, 2013 provides the legal framework for freezing the assets of a company when there is a concern that the removal, transfer, or disposal of the company's funds, assets, or properties might be done in a manner that could harm the interests of the company, its shareholders, creditors, or the public at large. This provision empowers the tribunal to take immediate action to prevent any potential harm during the course of an inquiry or investigation into the company's affairs. It is a safeguard designed to ensure that the assets of the company are protected and that there is no attempt to deplete them in a way that would negatively affect stakeholders or the general public. 1. Conditions for freezing of assets. Subsection 1 of Section 221 establishes the conditions under which the tribunal may intervene to freeze the assets of a company during an investigation or inquiry. These conditions can arise in a few scenarios, as outlined below. A. Referral by the central government. The central government may refer the matter to the tribunal when there is a concern about the company's actions regarding its assets. This could be triggered if the government believes that the company is engaging in practices that might harm its stakeholders. B. Inquiry or investigation. The tribunal may intervene when there is an inquiry or investigation into the company's affairs under the provisions of this chapter of the Companies Act. During such investigations, it may appear that the company is attempting to remove, transfer, or dispose of assets in a way that could be detrimental to its stakeholders or the public. C. Complaint by members or creditors. The provision also allows members, as specified under Section 244, or creditors, with a claim of at least 1 lakh rupees, to make a complaint to the tribunal. If such a complaint is made, and the tribunal deems it reasonable to believe that the company is planning to move or dispose of its assets inappropriately, it may take action to freeze those assets. D. Reasonable grounds for concern. The tribunal must find that there are reasonable grounds to believe that the removal, transfer, or disposal of funds, assets, or properties is likely to occur in a way that could be harmful to the interests of the company, its shareholders, creditors, or the public. If the tribunal is satisfied that such a situation exists, it may issue an order that freezes the assets or places restrictions on the transfer, removal, or disposal of the company's funds or assets. The order can remain in place for a period of time, which cannot exceed 3 years, or may continue subject to conditions or restrictions deemed appropriate by the tribunal. This provision is critical for ensuring that the company's assets are not misused or dissipated while an investigation or inquiry is ongoing. It is a preventive measure designed to protect the interests of the stakeholders, including shareholders, creditors, and the broader public. 2. Consequences of violating the tribunal's order. Subsection 2 addresses the consequences if the company, its officers, or its employees violate the order issued by the tribunal under subsection 1. If the company removes, transfers, or disposes of its assets in contravention of the tribunal's order, the following penalties are imposed. Penalties for the company. The company itself will be punishable with a fine. The fine imposed on the company will not be less than 1 lakh rupees but may extend to a maximum of 25 lakh rupees. This fine acts as a deterrent, ensuring that companies comply with the tribunal's orders and do not engage in activities that could undermine the investigation. Penalties for officers in default. Every officer of the company who is in default of this order may face more severe penalties. These officers may be punished with imprisonment for a term that may extend to 3 years. Fine which shall not be less than 50,000 rupees, but may extend to 5 lakh rupees. Both imprisonment and fine may also be imposed, depending on the circumstances of the violation. These penalties are intended to ensure compliance with the tribunal's order and to hold officers accountable for any actions that result in the improper removal, transfer, or disposal of the company's assets. The severity of the penalties reflects the seriousness with which the law treats such violations, as the wrongful disposal of assets can seriously harm the interests of shareholders, creditors, and the public. 3. Purpose and impact of the provisions. The primary objective of Section 221 is to prevent the improper disposal or removal of a company's assets during an inquiry or investigation. This provision is especially significant in cases where there is concern that the company may attempt to hide or dissipate assets that are critical to understanding its financial health or to protecting the interests of its stakeholders. By freezing assets, the tribunal ensures that the investigation can proceed without the risk of assets being moved or hidden. This provides a level of assurance to the creditors, shareholders, and the public that the investigation will be fair and that any potential wrongdoing can be properly addressed. The provision is also important in safeguarding the interests of creditors and shareholders, as it prevents actions that could diminish the value of the company's assets before any legal determinations or actions are taken. For more details, contact us.